Importance of preamble. It is a preamble that has to looked into for a reason for or the spirit of statute as a key to open the mind of the makers of the act and the mischief they intend to redress. The makers appears to have even alive to likely difficulties of the executive to live up the act. Edition date 23/9/2018. Asma Anjum versus Aligarh Muslim University in complaint. The golden rule of construction of a law is to rely upon the preamble of statute and the statements of objectives, and the reason is arrive at the true meaning of the word used in the enactment. According to the provision contained in various sections, need to read in the context of the objective of an act which is set out in the preamble to the Right of Information Act, viewed for a context of the RTA Act was enacted to set up a practical regime of RTA to secure access to information under the control of public authorities to promote transparency and accountability in the working of every public authority. The Act therefore aims to bring total transparency. The preamble clears a state it indeed harmonizes the need to keep certain matter secret, but at the same time retrieving the paramountcy of the act to know. Though the act intend to bring into total change in the mindset of secrecy generated by the colonial legislation such as Official Secret Act and the Law of Evidence. The preamble also outlines the ground that many necessity withholding of the information from the citizen. The preamble permits non-disclosure of information. It's like to cause conflict with the public interest, including efficient operation of government, optimum use of limited facial resources, prevention of confidentiality of sensitive information. This raises an important question. Can an information disclosure like to cause conflict with public interest and can be withheld by public authority? Interpretation. A right to information jury genuine has to understand the commissioner opinion on the basis how courts have interpreted the right under the Article 19 of Constitution. As I said, second, the relevant vintage. The principal contemporaneous exposition is not available in the opinion of CIC, as the sound rules of constitutional status finally established in England as far as in 1584, whereas head-on case was decided that for a sure true interpretation of all the statutes in general by the penal and beneficial, restrictive, enlarging the common law. Four things are to be discrete and consider. What are the common laws before making the act? What was the mischief, defect for which the common law did not provide? What remedy the parliament had resolved and appoint to cure the disease of commonwealth, and the true reason of the remedy. And the office all these judges have is always make such a construction, such suppress of mischief and advance of remedy, and to suppress suitable information and evasion of continuance of the mischief, and the pro privoto commando, and add force and life to the cure and remedy according to the true intent of the makers of the act pro bono publico. The commission held that it may be opt advert to the preamble to the RTA Act 2005, which spreads a promotion of transparency and accountability in working of every public authority. The preamble also stressed that information is vital for the efficient function of a democratic public, for the holding the governments and the instruments accountable to the governed. Needless to say, the decisions of the import of over 1,000,000 tons of wheat was taken by the competent authority, and the people of the country was entitled to know the decision making process involved therein. The commission ordered to supply the relevant portion of the material, that is CIC decision history, claim, Shing, Charan, Department of Food and Public Distribution appeal.